All right. All right. Welcome to tonight's broadcast from Seller Finance Consultants. Mark Stein and Terry Lewis here to talk to you and talk with Robert Eckley, attorney at law, practicing law in the major states on the West Coast, and well-versed and well-experienced in the world in and around alternative finance and pretty much everything in and around paper financing, real estate financing, seller financing, seller carries, lease options. We can go on and on. He's spoken at the National Association of Realtors annual event. He's spoken actually at the Supreme Court on issues of seller financing and pretty much all points in between. If you guys have any questions, go ahead and mark your questions in the question box. I want to make sure at this point everyone can hear us. And raise your hand if you cannot. No one is raising their hand. So we will continue and move right into tonight's presentation. As we mentioned, next week we're going to be speaking as a featured panelist at the Las Vegas Noteworthy Convention. It is the preeminent premier event in the industry, and it is pretty much the gold standard for paper investing, alternative financing, seller financing, pretty much all the stuff that we talk about and are interested in. And as such, we are going to be sharing the stage with Jim Eckley. We feel very honored to do so. We feel honored to speak at the event. We're super excited. And as well to do a webinar. This is something Terry and I have talked about and wanted to do for some time, and we've just we're absolutely excited to be able to ask questions. This is something we've never done in this litigious world. Jim is reluctant to give out answers to questions in a live format like this. So that being said, this is a really exciting webinar we're going to do, and probably will never do again, of course, unless we can talk him into doing this with us. So that being said, Jim, let's get right into it. We're going to ask you a few questions, go back and forth, and then as we promised, we're going to keep this short and go right into questions and answers and let our attendees ask their questions. What is your opinion on what is happening right now in 2014, and specifically in 2014 and beyond? You see this massive shift into heavy government regulation, obviously with the Dodd-Frank Act, which followed the S.A.F.E Act. And as well, we're seeing this big expansion in private lending, private finance, and this movement and shift back and forth between private finance and government regulation. Can we dig a little deep on that?
Well, I think you're on the right track, Mark, and I thank you for the introduction and for asking me in today. So I enjoy doing these. And, of course, attorneys always enjoy talking, so I enjoy that opportunity as well. First of all, not only are we talking about a 2014 change, but we're talking about the most recent months at the tail end of 2014, and these are becoming more interesting perhaps than what we had really wanted them to be. We see a great move on Wall Street, and the current feeling is that a bull market's being prepared to turn into a bear one pretty soon, and I think there's all kinds of indications that that's likely, and I think the folks that have serious risk management in mind would want to start hedging their bets, and we're seeing these hedges occur already. I jotted some notes this morning when I noticed that the Wall Street Journal, some of the other financial reporters are talking about the witching hour of October. And October seems to be a magic month traditionally in the United States, and it's had a lot of grief that's occurred in times where there's been overheated stock markets. It tends to be that October is the moment in which all of the bubbles burst. As an example, in October 19th of 1997, the journal reports there was a sudden crash on the marketplace of 20.5% of the entire equity on all of Wall Street was lost within a matter of seconds. Those that will remember that date will also know that Wall Street closed for almost 2 days to try to recover itself, which, by the way, quails when you look at 1929. 1929 was far less. The big crash of 1929 was October 28th, and the market lost 12.3% in about 4 hours. You can go back, and there's the 29 crash in the following. 37 was the crash. 2008 was another crash. If you remember, the market lost about 10%, again in about an hour and a half, blamed on a computer glitch, but actually blamed on the jitteriness of a marketplace that has been inflating longer than it even believes it ought to have been. And so for that reason, virtually everybody is waiting for that other shoe to drop and trying to get there, unfortunately, and change shoes at the last minute. Really, the better thing is what my dad told me years ago, and that is never wait on a good market to get the last 10%. Get out while the getting is good. It's those that wait for that last 10% that usually end up losing quite a bit of what they had. I made some notes about what I think is happening in that marketplace right now, and I'm just jotted them down, so I thought I would use these to prompt myself a little bit because I did some thinking about it. I have said that there's a changing economic picture right now. Yield-oriented investors are starting to leave Wall Street. They believe growth basis is eroding in artificial assets like stocks, which have no real collateral behind them and no real game plan other than to ride the bull marketplace for the highest bidder, or asset-based stocks, which are there, which seem to have no other game plan than the appreciation of the underlying assets, which themselves tend to be more stocks of the same type. So it can be a fool's game when everybody's heading for the door. With low common interest rates, the answer then is not just to exit stocks and go to money markets, such as those that are paying 1.25 point, which is the popular rate, and now a lot of those are going to be mark to market. So even money market will no longer be marked at $1 per share. It's going to have to be marked at its actual value, which will be considerably less. And it certainly isn't going to beat municipal bonds. Unfortunately, municipals have taken a terrible beating recently by a Fed ruling that has determined that they are not sufficient to be proprietarial capital for big lenders. So all the banks cannot hold those and count those as proprietarial capital. They are considered to be volatile right now because of things like Detroit and San Bernardino and other elements that have made that market weak and frightening. And for the first time, big municipalities and counties are defaulting on bonds, and in bankruptcy, the bondholders are not faring too well. So it's not going to be there. And from that standpoint, fleeing to real estate isn't an answer. For yield-oriented investors, in some cases, their charter with the big funds either won't permit them to hold real estate, won't permit them to manage it. They can't hold deeded real estate. And the stability of real estate has been less than the very stocks that they're leaving. It's true that we have seen some rises in real estate, but we've also seen ups and downs in real estate that's just too much of a variation or a gyration for a traditional institutional investor to put their money into. So what's left? It's a hedge. You're going to have to hedge. And in a transition marketplace, notes and paper makes the best hedge. I made some pin marks here to kind of help myself make that point a little clearer. The hedge then is not in pure fixed economic assets or pure fixed hard assets. It's the hedge, and that is where secured notes come in. First, real estate fluctuations become less of a concern when they're only collateral and not the only basis in the asset. And if you properly underwrote that loan originally so that you've got a good debt-to-equity ratio that was a rainy day ratio, meaning that if worst came to worst, you still had lots of equity between you and the loan and the value of that property, then you've hedged for that. Also, if you have a good cushion in the note and make the note a variable rate type note, for instance, so that it floats with the common rate out there, and as rates go up and down, you've hedged even for interest rate fluctuations and within some realm that makes it marketable. So obviously you've got the best of both worlds. If the world becomes a world of money and money becomes king and interest rates go up so that the value of money needs to go up, then you've got that built in, and if all collapses and you have to get back to hard assets, you don't have these symbolic assets such as stocks. You've got hard assets like realty. So if you're looking right now from the standpoint of what is the best hedge in a transition market, notes are it. And that's why right now there's a massive re-syndication of private notes. And I just got another figure that I pulled out of the journal. To date, this year, let's compare it to the prior year. Syndication money means people that collateralize notes, put it all together and build a syndicated participating interest like a bond out of underlying notes. And those notes can be secured or unsecured. And usually in times when there's lots and lots of conventional money and people feel better, there's not very much syndication. But when there's a lot of it, then it's obvious that all the smart money is fleeing to syndicating their own, not borrowing it from banks and not pulling it out of their back pocket But syndicating and selling that as a participating interest on the street, because it's interest, it's money, it's real life cash coming out of them. The typical syndicated amount of debt over the years has been about $1 trillion. Right now, the syndicated debt in the United States, just syndicated this year, is 2.4 trillion. 2.4 trillion. So that gives you an idea that where the smart and the big-time money is going has tended to be into debt. And using those debts, of course, most of them are all collateralized, like REITs, REMICs, all of these are collateralized. So they've got the best of both worlds. If money gets more dear, their money gets higher. They get interest. If their money gets less dear and assets take over, they always have the underlying portfolio of assets to support the collateralization of that loan, so that the bottom really is that maybe you have to liquidate the loan by going after the collateral or the borrower. If you've done your underwriting right, both will make you whole. So transitionary moment, Mark, I say the right way to hedge is with debt, collateralized debt, and there's plenty of it out there to be had because the government and the banks seem to be getting out of the business of making it easier for us to borrow. They're making it harder, so the likelihood is to go to your own money source by syndicating your own debt.
So Jim, this is Terry, and I really appreciate you being here on this this call. So you would say that the big boys have already been in this game for quite some time. It looks like 2.5 times what normal. They've already done it, and the name of the game is yield. And when I talk to people that are thinking about buying notes or investing, or even ones that are selling existing notes, I'm asking them, what kind of yield are you looking for? And I can never get an honest answer. And I know not so much an honest answer, but maybe that they just don't know what they want, or they have to obviously look at the whole deal. But someone should have somewhat of a mindset of what they're looking for, I would think. And then I guess going into the next question, what's going on with the I know personally, but I'd like for you to explain about the Dodd-Frank Act, and it seems like your mom and pop investors buying notes are probably going to be buying more single-family type notes. And so what's going on with that, and what gives them security, or what should make them feel secure in jumping into this market?
Hey, can I just add one sub point to your question, Terry? What I found amazing, and I think you were getting into it, I just wanted to drive it home. I saw an investor program just released in the last couple weeks, and the whole premise is on avoidance of Dodd-Frank, and that's his unique selling proposition. So just to paint the picture even more stark, I just wanted to put that out there.
Well, and I like the question. I'd like to give an answer to it, but yeah. I'd also like to go back to something Terry just mentioned, because it's something that comes up again and again. And Terry, Mark, all of us get these questions all the time, and that is, how much yield is enough? What should I be looking for in yield these days? That, if you want to follow the big institutional guys, the big guys that do the thinking, and the risk takers portion among them, you'd like to look someplace so that whatever you pick as a figure, you have some foundation for it to say, well, this makes sense because, and be able to point to something where other brains have been at work and have given you a signal. And in this case, I've used junk bonds on Wall Street. You know, everybody was buying into yield, and as you know, more and more money chasing less and less yield has driven people finally into junk bonds. And for a while, their junk bonds were doing pretty well, and they might still, I think, still be doing well till the balance of the year, because of course that's where the big yields are. And what has happened is the P&E ratios have now gotten so high that people are paying so much for so little yield on the more conventional returns that they're down to half and quarter point returns that are chump change, not even worth taking the risk. So those that are looking for yield went to the junk bonds. And here's where my feeling was that wherever they stopped buying junk, wherever the yield was not enough for the risk, was probably where the yield point is, the turning point. And I wanted to know where that number was for the big boys with the big money that were willing to take some risk, but not the risk of losing their capital. It turned out to be about 4.75%. Now, I don't tout that as being high or low, but here's where they turned around. They slowed down on buying junk bonds when the P&E ratio between the purchase price and the yield got down to 4.75. They weren't willing to go below that. So at least they're telling us 4.75 seems to be the endurance basement about what yield anybody should be looking for, because if the big money and the smart money doesn't want to go below that, there's no real reason to go below that. But it also tells you something else, that the same people that are buying junk bonds would be willing to buy paper that yields 4.75 and above. And as we all know, almost all paper yields way more than that, so it makes it a much more viable and a much more economical alternative. And I think that Wall Street crowd needs to hear that. Now let's go back and answer that question, which was, we've heard so much about the new government regulation. And of course the big one is the Dodd-Frank Act. And that came down in about 2010, June. And it was really a reaction, of course, to the collapse of the economy. It was very clear that we've virtually been put on the skids. And the feeling was that lousy loan practices, such as the see-through loans that essentially have no real borrower with no real money, and the collateral was not very adequate. It was just easy money times, and everybody was stamping those loans. And the belief was that it was that kind of attitude that knocked the bottom out when we finally got back to basics. And so the idea was it should never happen again, and that's why all this regulation came down. And attempts to it's super regulation. I mean, it gets right down into loan-to-value ratios that will be acceptable in order to put instruments on the secondary market and sell them. And most lenders need access, when they're big volume lenders, to that secondary market, so those rules are pretty darn tough. And they've gotten so tough that they actually dried up that marketplace, and that's what makes more and more room for people to develop private paper. But my feeling on it is this. If you follow the rules, then you have paper that has value. If you don't follow the rules, then you see defects in the paper that a smart paper buyer is going to use to either not buy the paper at all or discount it to points where you're going to lose money. So why have paper that stinks? That's an old Latin phrase we like to use a lot in the legal business. Why not have paper where the due diligence is going to pencil out, it's going to give you the highest yield, and the way to do it is cooperate with it. And this concept that's, for some reason, Dodd-Frank and the Consumer Financial Protection Act has absolutely no coverage for real estate brokers is crazy. Right in the enabling statute, it says that it does cover real estate practices and acts. And of course, you know, the CFPB took over HUD, took over RESPA, TILA, and all of those govern real estate acts, and specifically real estate brokers. So to say that if you're a real estate licensure or mortgage licensure, that you're somehow outside the act is just ludicrous. And that the instrument that you handle is somehow outside the act is worse than ludicrous. It's probably malpractice. So we're there. If we're there, let's deal with it. And it turns out if somebody just spends the time to read the rules, they're not that tough. And then one can go around with one's paper and say, not only that, but my paper's been vetted through the CFPB standards, and it meets them, actually exceeds them. And now that adds value to that paperwork and makes it far more valuable and far easier to traffic in the secondary market. You know, you can't do much with CFPB paper, that CFPB violating paper. Let me tell you why. Everybody that touches this, like Typhoid Mary, under the rules, everybody that touches that paper can become co-liable for a CFPB violation. So paper that was generated prior to January 10th of 2014 is going to be exempt unless you go back and amend it. So if you buy paper and you go back and you deal with the borrower and amend it somehow, it could even be such a thing as release tax reserves or add tax reserves. Any one of those things, touching that paper again now puts it under the new CFPB, and you're going to have to bring it all the way up to standards. Is it difficult to do? No. I don't know why there's all this naysaying. All you need is a lawyer and a mortgage broker that knows what they're talking about and wants to do it the right way to vet these things and clean them up. And they can be cleaned up. I recently cleaned up a $5 million portfolio that had CFPB violations in it. And all we did is find out where those violations were, go back to the original borrowers and correct them. Now the difference was that that portfolio was valued at $3.4 million because of the violations. And once we corrected them and cleaned up the paperwork, which was a legal cost of about, you know, not cheap, was 10 grand, but then it went for $4.3 million. So obviously that was a pretty darn good deal. It added way more than what it cost. And those things just demonstrate to you how valuable it is to add value to your paperwork by virtue of just cooperating with the rules. So there's my answer to that one.
So what we're saying here is you know, basically, Jim, you and I have been conversing for about 3 years now in anticipation of all these things coming out, and really we're adding value as a mortgage loan originator and as you an attorney to the value of paper, and whatever that cost is can be during the origination of the paper can be paid by either a borrower or the seller or the real estate agent or parties involved, as long as it's all disclosed properly.
True, and it has a cap. Can't go more than 3% of the amount of the loan. So there's some caps that are required. But you know what? 3% is plenty of room. And remember, we were talking about seller carry paper, moms and pops out there. The one place that you can go for super value here is to be the one that originates the paper. Lots of times the originator is the one that can make the most money out of these. And rather than go around and say, can I buy some of that paper, I've always thought that mortgage brokers and bankers, and certainly real estate licensees, ought to be those that suggest originating the paper. So let's say you've got a mom or a pop that wants to sell their property, and of course everybody wants cash. But maybe they can't find it because they got borrowers that are the most likely to borrow, have credit stink jackets on them that they got sometime after 2007 because they did like a strategic give back. They're well off financially, they've got money, they've got jobs, they've got money in the bank, but they've got a stinky FICO score and it's going to take them a few years to shed it. What a great potential buyer on seller carry. They're not going to make it under any conventional loan, but they will make it under a seller carry, and they'll be darn good candidates and a really good value. So why not then arrange to have that sale made first on a seller carry, and then promptly turn around and sell it to somebody like yourself and turn it back into cash. So the seller still gets their money, and they still get it all right now, but they just do it now in 2 deals rather than 1, and it's back-to-back and usually right inside the escrow. So there now suddenly you can generate brand new paper and make all the money that needs to be made right there. Do enough of those deals and maybe even buy some of that paper, and you can package it up. And when it's packaged now, it can sell as a package. And those now are the things that you can sell when I call it the secondary market. It could be to another paper buyer. And you can generate a different yield. You could, for instance, generate a higher yield by maybe loaning the original money at 7% on a seller carry, which, by the way, that's pretty much what people are doing. And then oversell it a little bit because you can sell it for a higher price because the terms, i.e., they're going to get this loan and they're not going to get any other loan, so they'll usually pay a little bit more for that property. And so that if you even sold it for a 3% discount over face, so if the new investor got a 10% yield, between that and the oversale on the sale price, you're still going to get all your money back. It still nets it out. And now you can make deals where deals could not be made before. And everybody makes some money out of it, and the seller and the buyer both land on their feet. How could anybody not want to do things like that?
Yeah, it's really powerful, and I just don't, it takes a little bit of thinking, but I think there's so much opportunity out there. So one last question. It looks like we're coming up on our half hour.
Wait, let me chime in with a just to set us up where we're going here. And Jim, you'll remember towards the earlier part of the year, we were talking just about Back to the Future, a popular movie, obviously in the 80s, and we were talking about the experience of real estate in the 80s. So could you briefly hit on strategy and the more global and more general acceptance of seller carries, as we affectionately say, are not today and going forward, and we can see the growth over the last 4 years, and certainly just talking about where we're headed in a tight credit market, where seller carrybacks are not going to be takeout at your local Forebearance.
Well, thanks for using that analogy, and you stole that from me. Shame
I
on
did.
You. I'll have to charge you for that. Terry was making a joke, or Mark was making a joke there, and that is that a lot of people that have recently got into the industry think that a seller carry is takeout at Denny's or Filiberto's. They have no idea that that's actually an instrument. And it's an instrument that I want to say that has dignity. See, a lot of folks really think that, oh, that's some sort of a back room instrument or a dark force instrument or something that should be done in a back alleyway, and it's not. Those of you who have lived as long as I have, I think I went to real estate school with Moses. I remember him somewhat there. Those of you who are old as I am and have been in the industry know that this has all happened before. And the good example of that is the late 80s. As you'll recall, those of you who are living during that period, I hope some of those who tuned in today were living during that period, the interest rates had been deregulated by the Monetary Liberalization Act of March 1981. Which means they took the lid off, and there was no such things really as usury anymore. And so the banks loved that, and they absolutely went crazy with it and finally got up to 19% interest on an ordinary first mortgage loan to purchase a property, which effectively cut off all finance, just ended it. Now, of course, if we wanted to pay 19%, it was available, and they'd always say, hey, we got plenty of cash, loads of it. Come down, pay 19, you can get it. And essentially the marketplace realized it could not live with 19%. People that wanted to resell their homes couldn't resell them because no one could pay 19%. So here's what happened. Seller carries were reinvented. And seller carries didn't have to charge 19, and it saved the marketplace. In 1988, 30% of the marketplace was seller carries. Unless you lived then and knew, you would not be aware of that. And the escrows all did them, and everybody knew what they were, and it was the first request that everybody made. And by the way, you know, there's that multi-list, and it has that little box, seller will carry. It's crazy how many people do not check that box anymore. Then everybody checked it because, hey, you want to hear what anybody has to offer. Isn't that what we're doing here, is offering this property to the highest bidder that can come in with some money on a deal that's worth taking? So that's what you had to do back in those days, and it virtually saved the marketplace. Remember, it was 30%. If that 30% had not been there, there wouldn't be a marketplace. So we've been here and done that before, and it worked. So there is a track record of working. It's not a back alley thing, and it's provided by statute in every single state. Every state has seller carry. So who in the world would say to their client, as a real estate licensee or otherwise, oh, we got to stay away from those, they're criminal, or not tell their client about the availability, whether they're a seller or a buyer?
They're illegal.
Yeah, which is obviously a complete malpractice and a fraud to say something like that. They're legal. Right now, let's look at some other places to show how conventional they are. Most commercial sales are like that. Very few commercial sales nowadays are all cash, or going down and buying it through a loan. And by the way, when you do pay off that seller, and seller has a low basis, and you pay them all off in cash with a refinance, their tax bill is enormous. They do it on a seller carry, they can take the installment gain treatment, and they pay less tax over time than what they would have had you done that. Ranches and farms, going businesses, always been on seller carries. Very difficult to find any conventional money. They've been out of conventional money for years, and that's about the only thing that supports them. So it's not a back alley deal. It's the real thing. It's another technique, and it needs to be used. So, you know, I'm glad you let me get on my horse on that one, but I thought that it, and crow, because it makes me mad as heck, because remember our duties, and it doesn't matter who you are. If you're a licensee, and you're an investment advisor, or you're a mortgage broker, or you're a real estate licensee, or you're an attorney, or you're an accountant, we all owe fiduciary duties to our clients to be able to put them someplace that's better than where they're at and where they're trying to go. And the only way to do that is to have a degree of latitude that allows them to know of any lawful way of getting there and allow them to make the choice. And certainly some people may say, I don't want to do a seller carry. Well, if you said, well, seller carry means you have to wait for all your money. No, it doesn't. You can turn that into paper and sell that tomorrow. That seller carry's got value today. So all of these are misstatements, and they're wrong, and it means you don't make any money if that's where you get your money. And certainly your clients and your customers' objectives are frustrated, and wrongfully, and with misinformation. So I just think it's asking for it. I'd like to see a lot more paper generated out there, and I think even in those cases where somebody can pay cash. It's called leverage. Why wouldn't you want, as a buyer, to have the leverage of using somebody else's money to leverage your way into that property, particularly if you believe in growth, because the less you can put in there and just let the growth float. Remember, the growth works on the principal, works on the value, not on the amount you put in. You can put $1 in to hold $100,000 worth of real estate that returns only 1% a year. Well, if it returns 1% a year, that's $1,000 a year on your $1. Now, what kind of return is that on $1? So people have tended to forget these things. That's not a back alley deal. It's right out in front of God and everybody, and ought to be used more often.
So we're about to wrap up our primary interview part of this broadcast, and certainly as we do, we want to invite all the listeners to go ahead and scroll down to the questions box and simply hit the plus sign where it says questions and enter your questions. We have some questions to be answered, and before we do, I just want to make sure that I have one more question for Jim. Terry, do you have anything else before I ask a final question, then we move to questions for our listeners?
I've gotten a lot of inquiries lately on lease options, and people wanting to actually sell them or find out how they could be monetized so they can get their money and maybe do it again. I think lease options in that 2008 burst. A lot of people bought really cheap properties and then put buyers back in them, under contracts. But now they're kind of stuck. So what do you can we convert those into notes and deeds, or what do you think, Jim?
Well, my feeling is almost everything can be turned into some sort of an instrument that can be traded as opposed to the hard asset that might underlie it. And certainly on lease options, you're right, absolutely. There are a lot of those out there. A lot of folks bought primarily for investment purposes. They put tenants in there, and over time, some of them started thinking maybe it would be a wise idea, since they're good tenants, to give them an option to buy it, to give them more incentive to pay perhaps a higher lease, or to stay there and treat the property better. And sometimes they're going to use those and sometimes they're not. Now, I will tell you something. A properly written lease option, I've had experience with those. I've written several thousand of them over the years between several different states. A properly written lease option has enough incentives in it for the lessee optioning to exercise it about 70 to 80% of the time. So it's not a goofy deal. It's something that can actually come to fruit in being exercised. So I wouldn't pass on that as a likelihood in valuing it. But let's just go to the question that you gave me, and that is, what would you do with just a big basket of lease options? Well, the first thing I go to them and see is if they want to turn it into a purchase. Some of them would like to, very much. Let's just do it now. Now, some people may back up and say, no, I don't think we're ready to do that. But we do have an income flow here. So what do we do with that? Well, one of the ways we handle it is we'll, for instance, start an LLC, and we'll assign the income flow into the LLC. And we can sell participating interest in the LLC to those that would like a percentage of that cash flow. So of an overall cash flow that comes in from all those lease options, we retain maybe 1% and be management and make sure that it all passes through and they get their dividend check every month. And then they come in and they buy their interest. They pay you all cash for it. That's how they liquidate the future value of the cash payments to come out. And then you give them their cash payments. Now, some could even be a participating interest for only 5 years. In other words, not just buying that income stream until the end of the lease, but they could be one that they only buy the income stream for a year or buy it for 2 years. There's any way you can slice this. Now, the bad word for that that we've heard in the past 10 years is called a derivative. But the good word for it is it's real live money, and it can be sliced up however you want to. So there's a way to collateralize all of those lease options and make that income flow a soluble flow right now.
Very good.
So, Jim, one last question, and not to toot all of our own horns, but we've all been involved in transactions.
Oh, no, let's do that.
We've all been involved in transactions wherein we were able to go in and essentially create, when we were selling notes off, we were able to actually get our sellers a bigger price on the sale of their notes. And it's interesting because we hear, again, people wanting to avoid bringing in professionals for the purpose, obviously, of saving money, because why else would you want free insurance? But we've actually been able to demonstrate to some of the clients that we've worked with upon selling their notes that we've been able to get a bigger return. So they've had a return on their investment, and a lot of times we're able to get their clients, anyways, the buyer, to pay for these services to make sure that their paper is compliant with, and because, again, it's federal law. Can you talk about that briefly, and then after that we're going to move right into our listeners' questions and proceed.
Long-term fixed cash flow, or cash flow that is attached to a variable rate that can fluctuate up and down based upon other events in society that might make that cash flow worth more or less, and it negatives that variance by virtue of following those events and increasing or decreasing the return on it based upon those events, has a value over time that may be in excess of its value today. In other words, the ability to get it for 30 years many times is worth far more than the ability to get it for a year. So you can actually find instruments that have been written so well at the primary level where they're originated, between the note, the borrower's strength, and the underlying collateral, and the way the note is written to ride with the marketplace, that it actually has more value than what it might currently have on a long-term basis. You can put prepayment penalties in it to discourage prepayment, and in some cases there's other clauses you can use to make sure that you can count on that yield for many, many years into the future. Those are the kind of contracts that you could have, for instance, a face value on the contract of, let's make it a $500,000 sale, and bearing, say, let's make it easy, 6 or 7%. Those are contracts that you could sell many times for an actual premium, not a discount. A premium because they're written in a way that the holder can count on 6 or 7 years of that kind of money, maybe a variable rate note, so it'll go up if interest rates go up. So it has flexibility based upon future market events where they might pay you a 5 to 6 point premium over the top of that purchase price in order to have that note. So there are cases, we've been talking about discounts, trying to avoid discounts by having non-conforming notes. There are places where the note is so darn well written that it is least objectionable and would actually command a premium on the marketplace. Now, who knows how to write those? Well, obviously the folks that are educated on it and sit down and write these things every single day. Not to mention the fact that people who have segues into the marketplace. Do remember that most people don't know where to go to sell a note. I guess they look in the internet and they find somebody that says note dealer and they go to them. But in reality, the guy that knows best how to place your note is the guy that helps you originate it. And many times he's already originating it on rates and terms that he knows he can resell and get a good price. So from that standpoint, that has all kinds of value. And it's why you use those professionals. And there's one last reason. Remember what we all need, and that is if all things go wrong, we need someone to blame. Now, if you do it yourself, you have no one to blame but yourself, and that's kind of tough. But if you have a professional handle it and it doesn't work out, you have them to blame, and that helps greatly emotionally. I don't know what the discount points are for that or the premium is, but it does help.
So you would say a surgeon who operates on himself has a fool for a patient?
Yeah, that's true. They used to use that for the lawyers. They said the lawyer represents himself as a fool for a client. But that goes right down with other anachronisms like reasonable attorney's fees. Does that really fit? Or help me find a good lawyer? I mean, come on. I think we all know that Santa Claus, really isn't out there after all. So why would we use clauses like that? Go ahead. What else is your next question?
Well, we're going to move right into our listeners' questions, and Terry and I are just going to kind of rifle through them. We'll just take our turns so you don't get tired of hearing either one of our voices. And go ahead, Terry. We'll let you ask the first one.
We have a question, a really good one, on a forbearance and a modification. There's a lot of second trust deeds out there that are getting modified or forbearance. And what are the pitfalls of people that do those? A lot of mom and pops are buying these notes and working them out themselves. And so is Dodd-Frank part of that, or state licensure? Where's that headed? I think I have the answer, but...
Well, it doesn't matter what status the note is, whether it's a first, second, or a third, but it can matter whether or not that note has been modified and is under a current modification program. Now, I'm going to cover that first part because there's a lot of folks out there that think that the way to buy and sell property is to go to somebody who has modified their instrument and they're on the modification, and therefore it's a very reduced monthly payment, maybe even a reduced overall payment, and then sell that on a wraparound, for instance, contract to someone else and take all the upside that the government just gave that borrower by writing that loan down. And that, unfortunately, is a federal crime. All of these are governed, these programs are all governed by the feds, and those kind of write-downs are anticipated that it's purely for that borrower on the basis of hardship and specifically qualifying. Those cannot be sold out there without violating federal law, and I think some of these lenders don't even know that, and so they sell a modified instrument. You can be stuck by that modification on a resale of it, and no one has really sat down and looked at the compliance features of that. It certainly now is back into Dodd-Frank and CFPB. Why? Because you're going to enforce it. If you're going to enforce it, say it's in delinquency, then you're going to have to use the remedies that are available. And if that instrument has defects in it that were written into it originally, and it could have such things as transactional defects, that gives the borrower a defense. In other words, it could be that that note was originated out of a sale or an appraisal that was defective. Well, you're going to face that borrower perhaps counterclaiming when you go to enforce it by saying, well, this was a false appraisal, or someone signed my name to those documents and that's not me, or there's some deed issue that has not been cured. And I've had several of those come in that are pretty large. It's amazing to me how messed up seconds typically are, and no one actually did any of the due diligence on that to find those issues before you bought it. So you can take those seconds that look so good on top and find out that once you get down to the bottom of them, they can be pretty darn ugly. I'll give you another one that comes out of California a lot of times. Lenders have always taken the position in California that a second position or a third position loan is a deficiency instrument, meaning you can foreclose on the property, and if there's any shortfall between the sale proceeds and the note, you can go after the borrower for it, or you can even waive that and go after the borrower on the note if they're good for it. That actually is not true, and let me tell you why. That would be true if the note was not used originally to purchase the property. If it's a purchase money instrument, and it doesn't matter whether it's headed to, it's a HELOC or a second or a third or a fifth, the mortgage broker that put that deal together originally to finance the property was probably just trying to get 100% finance. So they were stacking mortgages up, but every dime of those, if you go back to the HUD ones, was used to purchase it. Well, in California, if it was a purchase money mortgage, doesn't matter what the title is, how was it used? How does this duck walk, not whether it quacks? Then you have no deficiency at all. And what you bought, thinking that you'd have some right to pursue the borrower, you don't have any right at all. The only thing you have is the right to get the property back. And that property may be a real pigsty at that point in time, so a lot of them are. So you get some pretty big surprises on seconds unless you allow an expert to get involved and vet these. And most of the lenders sell them as is, where is, meaning that if you don't like that second and it comes back and bites you, and the borrower comes after you for 5 times more than what you're coming after them for, you usually don't have any recourse right. So the lender says, tough luck, sorry about that, and you're on your own. So those are some of the ramifications of buying those instruments without any professional assistance.
So on a modification or a forbearance where investors that are buying these at a deep, deep discount and then rewriting the terms in them, right now they apply under Dodd-Frank?
Yeah, they would. The remedies apply, and then if they touch the loan and modify it somehow, or they bought it as a modified loan and it was modified after January 10th. Anytime you touch that after January 10th, which is when everything went hard with the CFPB, automatically it all applies just as though you were at the beginning. So if they failed to comply, remember, as I said, that liability passes with the instrument. It doesn't matter how innocent you are. You're faced, if you try to enforce an instrument that's defective under the CFPB, you're exposed to the same liabilities. So there's some real, yes, they got them at a deep discount, but why do you think? I mean, in a sense, the banks are not dummies, right? They've got a legal department. They took a look at that and they passed it to you with tongs, 8-foot-long tongs, because it was so hot, it was so radioactive. They sure as heck didn't want to foreclose it. They'd much rather you go out there on an as-is, where-is basis and take the licks.
So, Jim, as well, another thing we've seen recently, a pretty famous investor, quote-unquote, guru around in Southern California, we obviously aren't going to name names, is going around telling people to just write it up when you take over a note and buy a non-performer, you write it up as a forbearance, and therefore now you're not subject to Dodd-Frank. So you can't call a chicken a duck and get away with it that way?
You can't. Forbearances simply don't work. I mean, remember this, Dodd-Frank was intended to be all-inclusive. And Dodd-Frank approaches this from a different way. What it does is not necessarily look at the act or the practice. It looks at the instrument. If the instrument was originally a consumer debt, there's the big key. Is this a consumer debt, which means it was used for personal residence or a member of the immediate household, and it was for personal, family, or household use, and it was not for a business or a commercial reason or an investment property. You bought a property and you lived in it. Then it is a consumer note. And that consumer note then has rights and responsibilities and enforcement limitations that pass with it no matter how many times it's passed. It is impossible to take a consumer note free of the defenses of the consumer, even if you're the 5th or the 10th buyer, under the Uniform Article 3, the Uniform Commercial Code, which has been adopted in California and most other states. That's really the guiding note statute for negotiable instruments. It's impossible to take it free of defenses. So you virtually have all the real defenses, whether there was a CFPB or not, whether or not there was anything called a forbearance, unless you want to call your forbearance some kind of a settlement with the borrower, which even then is a settlement on a consumer note and would still need to comply with the CFPB if it happened after January 10th. So there's no way to get around it. If you look at the note, it's the note that counts, and if that's where it originated, it comes with all the real defenses. In other words, whether the ones they would have had, whether there was a CFPB or not, and it also comes with all the CFPB influences about how much interest it can bear, how it can be foreclosed, what the debt-to-equity ratio has to be, what you can do to that borrower. There is a new act that came out that's enforceable both by the FTC and has been for many years, called, it was UDAP, and now it's UDAAP as adopted by the CFPB. And in a sense, it bars any and all acts after you get past all of the specific acts that one can or cannot do. It's an omnibus clause at the bottom. It says, and as to persons in a commercial sense, in a consumer loan, if they're in a consumer loan, if they missed it anyplace else, you also cannot do anything against them that might be deemed unfair or abusive, and leaves it at that. Excuse me, which means that the final test on a consumer paper isn't whether you can find it in the statutes as specifically prohibited, but as to whether some jury or some judge or a CFPB auditor at some point in the future might deem that whatever you did or whatever was done since the day that note was originated with that borrower was unfair or abusive, and it doesn't have to outline what. So what it means then is, rather than taking the chance that the little dings and bangs and scratches on that note, well, they may still pass muster and not be deemed abusive and unfair, probably the better thing is to take a note that's clean. And yes, you can cure defects in it. You can go back to the original borrower and cure it, but forbearances are not the way to do it. There is absolutely no exclusion in any of the federal rules governing commercial paper, consumer paper, and I'll get into why I keep slipping into commercial here in a minute, that says that any of that is waived. There is no way. If the act itself is wrongful, abusive, unfair, or violates something in the CFPB and all the other HUD rules and you name it, then it's going to be actionable, and it's a complete defense on the debt. Now, why do I keep stumbling back over commercial paper? Commercial paper is instruments that have been generated that are not consumer paper. They were not for personal, family, or household use, or for residents with personal occupancy. They were generated for purposes of securing business or investment property. Now, business or investment property is different. That kicks you completely out of the CFPB. So, for instance, if you're talking about multifamily housing notes, you generate a great big mortgage on a multifamily housing, and then you sell that because you've sold the multifamily housing, and now you've got a TD and a note, and you want to market it. That is not a CFPB instrument. That is a commercial instrument, and that one doesn't have to comply with the CFPB. So there's a big difference. Now, is it possible, let's say, for instance, to buy a property? You bought it originally from the lender, with the lender's loan and from the original seller, as a personal family residence. And later you turned it into a rental. And it's a rental when you sell it. And the person you sell it to intends upon continuing to use it as a rental and signs a certificate, which people like yourselves generate, the LMO certificate, that so states. Is that inside the CFPB? Answer, no. It's not a consumer paper anymore. So the answer is to yes, you can fix the dates. Yes, you can bring that paper back up to value. Yes, you can go all the way back to the borrower. But to suddenly think that just some arbitrary 4-page document called a forbearance or a workout or something solves all your CFPB problems is a complete mistake. It miscasts the facts.
So next, yeah, great explanation, Jim. And there's really no gray area is what is the message that we continue to try to hammer into people's heads. It just is what it is. So next question. Where are the CFPB violations of the Dodd-Frank Act found? Where are they to be found?
Well, probably the easiest way is if you have no social life, which that describes me completely. You could sit down and read all 12,000 pages, because between the Dodd-Frank Act and the CFPB and all the rules and regulations that have been promulgated under it by the various agencies, it's about 12,000 pages. So you can do that. Or you can take the shortcut and hire a lawyer and a licensed mortgage originator that knows the rules and can help you with them without having to sit down and give you a law school education on why you need to do X, Y, or Z. If a person really, just as a morbid curiosity and wants to sit down and waste some of their time by not doing any of the above and do all this work themselves, probably the best place to look for a lead, since the only way to do it would be to sit down and recite 12,000 pages, would be to go to my website, which is www.eckleylaw, that's ECKLEYLAW.com. Go to the articles section, type in CFPB, and let it find some articles. There's about $1 million worth of legal advice on that line. It'll find you the free articles that we've written about it. Try to find the most recent one, because some of these go back years and years, and you want the most recent one. And it'll give you the citations to the place to go, so that you can log onto the internet and go find it and read it for yourself. Most of it's legalese, there in betwixt and here and above and things like that, the things that only lawyers would love. Remember, all lawyers, when they were born, they took flies and picked their wings off to watch them flap their stubs. They had something sinister about them to begin with, so it's only right that they sit down and worry about fly specks over 12,000 pages. And if you really want to do that, it's okay. But that's why we make the bucks, because we do the boring reading, and then we come out and be responsible for our advice. And we try to give you the shorthand version, which is usually what most investors really want.
Yeah, and ultimately, again, this is a message that we echo and just really are spreading out there, and people are finally starting to listen. This is your investment you're dealing with, and if you're a licensee, certainly a lot of our clients are real estate agents, and we actually even have some mortgage lenders that are licensed. If there's any gray area, ask, because it's all gray area, which means you really need to be in compliance, and ultimately a lot of times the buyer is paying these fees. So, and the buyer in paying these fees, they're actually paying less than they would pay for a regular origination. So there's really nothing to fear in terms of bringing aboard what we call free insurance, and we encourage you to do it.
Well, and let's look at it one other way. Now, you and I have been talking for some time about seller carries, because we really think it's a way to salvage this marketplace and actually bring value back to it and make deals happen that couldn't otherwise make it. Because you do have to admit, a lot of it is the inability to even reach finance. There's a huge cadre, probably 25 to 35% of the potential market, that are moms and pops who gave their house back because they paid $1.5 million for a $500,000 house when the bottom fell out. And they were in a non-deficiency state like California, Arizona, and a couple others that are either totally non-deficient or modestly so. They gave it back as a strategic default. They just handed the keys. They called it jingle mail. Here's the keys, here's the deed, and the garage door opener, it's yours. Well, okay, that was the end of that debt. They don't owe it anymore, but they've got a very nasty FICO jacket, something maybe in the 600s, and that's not going to entitle them to get back into that marketplace. And yet they've got money in the bank, they've got 2 401ks, and they're both successfully employed. They're probably the best potential buyer and borrower you could imagine. And those people are off the market, and they're desperate to get back in it. They don't want to rent anymore. They want to get back into that market and get equity. They know what it tastes like. And there's no better time than now, which is the bottom of the market. And with interest rates being what they are, again, no better time than now. And if they sign one of these contracts and perform under it for 3 to 5 years before you put the balloon in it, then they've reestablished their credit. They've got a credit track again of paying on a secured loan of some amount that was large enough to be able to qualify for credit reporting and use as credit if they wish to for their credit history. So for them, it may be the only act in town. It could be for many years to come. Now, you can bring those people virtually out of the woodwork by giving them that opportunity. Now, we've talked about seller carries, but let's look at one other thing. Now, I could go to you or Terry, couldn't I, and say, look, I've got a couple of $1 million, and it's been sitting at First National or U.S. National or Chase, making the magnificent sum of 1/4 point. Last year, it was enough to buy gas for my car.
For 1 month.
Yield. The total yield, yes. So is there something I can buy into? Are you the right guys to go to if I want to buy into some paper where it's going to give me a nice yield, and you're going to vet it out and make sure that it seems like it's well secured, so I can just sit back and start clipping some coupons here and get my dividend check in the mail every darn month and still own that portfolio? Is that something you guys could do?
Absolutely.
Isn't that the real paper market? Isn't that it? That's it, isn't it?
Yeah, someone we really respect, he talks about this idea of 35 times your dollar, and he says, people that are out there taking their money to a bank, well, in this, they can easily get 35 times in interest what they would be able to get otherwise at the bank. So versus buying 1 bag of groceries at the market, wouldn't it be that much more powerful to be able to have the purchase power of 35? How many more, gallons of milk, et cetera, can you buy?
And it's a better hedge, too, and it also brings somebody else out. You see, it brings out those folks that don't want to buy, don't want to sell, and have no seller carries to sell or camp on and bank on. It gives them the opportunity, those moms and pops up in the hillside that have had some pretty good money and been living on the interest. Remember all those people that had the temerity to save money rather than blow it? Those poor folks have been whacked, too, since 2007. Here they have a pile of money. They were living on the interest. It's gone, and now they're invading the principal. And as you know, when principal goes down, the yield's even less and less and less, and they're scared. They need some kind of yield, and they go down and talk to their private banker at their local bank, and they say, you're right. With $8.5 million in cash in the bank, you're right. You're entitled to special treatment. By God, we're going to take that 1/4 point you've been making on your savings account, and we're kicking that up to 0.35 tomorrow. And you say, where did you get with that? How about the opportunity to sit back again with a passive portfolio that's making money, that's making way more than that, and it's coming in every month, and there's a ready market to go out and resell it anytime you want to back out of that. And it's a good hedge. It's a lot better than Wall Street right now. I mean, really, would you, if you had $8 million in the bank right now, would you really put it in Wall Street? Would you really? Well,
you could lose it all.
Yeah, if that's the case, there might be a better way to do it. Just go down and put it all on black down at the local casino and spin that roulette wheel, because that's about a 50-50 shot right now. Crap odds. Those are not good.
It's more fun.
It's certainly exhilarating, but only exhilarating for about the 4 seconds it takes you to lose every nickel that you laid down.
I have to say, Jim, that out of all the calls that I'm getting on people inquiring on seller financing, some of the investors and the sellers, I'm getting as many calls from, I guess, investors, for lack of a better word, people that have money that are looking to buy notes. And so it's like a 50-50 on both sides. We're actually the middleman. We're creating them, and I know where they're at, and I know what yield people are looking for in the process of what we're doing, and it's really powerful to be able to do that.
Well, I've seen some of that because I know that some of that work you've sent over in my direction, and it's always been good work and fun to do with good quality paper and good quality folks. So it's out there, folks. This is another viable alternative. Is it the one we all want? Is it the way that Mother did it? Not necessarily. But it is a technique. And what people come to us for in this industry is answers, solutions. They've got to have them. Now, sometimes the solutions aren't as good as what you'd like them to be, and it may even be in an area that makes them feel semi-uncomfortable. But the reality is you have to change with the times. It's a little bit of bending with the breeze. If you don't, you break. And the times have changed. And the likelihood is, with federal statute now in place that has regulated loans to a point that may be a long time before money is liberalized again for this economy, that sitting around and waiting for the old days to come back again is a fool's paradise. They're not likely to, because statutes in place now to assure that they do not. So absent some massive legislative change out there, the old days have been dead and have been buried regulatorily. They're not going to be here anymore, so now we've got to get onto the new paradigm, the new game plan. And the best and fastest we learn that, the more we can serve ourselves and the customers and clients that work with it.
Back to a micro vision of this stuff. With the debt that the country has, the government can't afford to pay more than that 0.5% or 0.25% on interest on the debt. So I believe that, as a conspiracy theory maybe, that these rates are going to be here for some time to come, and people better get on the bandwagon and start looking for those alternative ways to have retirement income and to have interest income and yield on their money.
Well, you can see right now that the government has said continuously that it's going to back out of buying all those bonds and treasuries and supporting the marketplace, and it has been doing that. And it's been saying that at such time as it feels that the market is stable, that that's the time that interest rates will rise. In 2013, they predicted that would be in 2014. That didn't happen. In 2014, they're predicting that would be in 2015. Now we have Yelton, who is our Federal Reserve Chairman, saying essentially that she can't tell you when it's going to be, and she's not even saying 2015 anymore. It seems to me that the government has been addicted to the cheap money scenario, and it's going to stay there. I don't really think, after all these preachings, that it's going to change, that it's really going to change, particularly in the foreseeable future. So now you have your choice. You sit there and wait to see if it ever changes. Again, just standing still. Very few problems are ever solved by deferring and doing nothing. Or you start taking action. And maybe the action isn't the very best one that you can think of, or the one you'd really like to have. But it's better than sitting still, and it produces yield, hopefully, beyond the yield that you can expect if you sit around and wait for things to come back that maybe aren't going to. And if you put enough flexibility into whatever you do so that you can back out of it or change it whenever the market changes, then you've already built in the escape valve in the event that you have to change. So you just don't get too fixed into things. You get enough fixed to get the yield that you want and to be able to have the versatility that you probably need in order to change when times change. These are uncertain times and ambiguous times. And so one needs to always have a few fire escapes in all of their investments And the beauty about notes right now is that they're wanted virtually everywhere, not just here but internationally. They can transfer themselves anywhere. They can be bought and sold anywhere. And everybody understands cash flow. And when you get right down to it, cash really is king, despite what we were told over the last 10 years prior to the Great Crash, when it was that stuff was everything. Well, and money was nothing. Well, here's what I found out. My dad told me this many, many years ago. He says stuff many times cannot turn into money, but money can always turn into stuff. So, and that theory then, it's always best to start with the basis of money.
So next question is, and this might be a better question. I'll let you decide if you want to answer this one or not, Jim.
We're running out of time also, Mark.
Yeah, I know. So go ahead and chime in if you want, Terry.
No, go ahead.
The seller originating a note, what kind of discount, what's the minimum discount a seller in origination of a note should expect?
I mean but there's a couple of uses of the word discount. You mean if they turned around and resold it, what kind of discount should they expect?
Yeah, a resold note. He didn't specify seasoning, so you just have to kind of fill in the blanks. And
also sometimes the word discount is the net after all of the transactional costs and brokerage costs. My feeling is that it's all a function of what the yield is on the instrument.
Sure.
Now, when I look at these, let me tell you, I wrote down, because I had just recently been asked and I anticipated this question, but I wrote down the things that make a great note. And these are the things that can make a premium. Now, if you miss a few of them, then what it might mean is the net is that you don't make as much out of it. You get a lower return out of it than what you would hope for on a resale. But if you put these in the initial note at the origination stage, these are the things that not just get you something that's a return that's commensurate with the amount on the note, but could actually get you a premium because you did it so well. Just take a second here. These are just my little handwritten notes. I actually have a brochure on these, but lawyers, they talk and talk and talk. So I tried to take and condense a large one down into a small one. And these are the things we're going to be talking about at that noteworthy convention. But first of all, you have to determine whether you're an asset-based creditor or whether you're a borrower-based. If you're borrower-based, you're looking at the strength of the borrower. If you're asset-based, you're deciding that at the basics, borrowers can go bankrupt. Land just doesn't disappear. Land always has value. Unlike stocks that can be worth nothing tomorrow and have absolutely nothing behind them, they didn't call it real estate for nothing. Land always has some kind of value. If you rated it appropriately at the beginning through appraisal, then you'll have a bottom line even through liquidation that'll still make you money. So ask yourself which it is. Now, most of the loans in California for many, many years were asset-based. That's why they were appraised. The borrower wasn't valued because it was a non-deficiency state. So the willingness of the borrower to pay, you don't want a bad credit jacket in the past because then that shows you're kind of you're a truculent borrower. You want someone that has had a relatively clean credit report, but it's not something that you can look at and say, hey, you know what, if he doesn't pay, I can at least go down and garnish on his savings. And he maybe even has a large number of savings. The fact is, can't do that in non-deficiency. So many states, you have to decide whether you're a borrower-based or an asset-based lender based upon state law. Secondly, and that segues right into, is it a deficiency or a non-deficiency state? Now, if you've done a pure second, you've just loaned money, not for the purchase of the property, on a consumer property, then there is a deficiency. All the non-deficiency states say, but that's only on consumer paper, and that's only when it was used for purchase of the loan, now of the property. And if it wasn't, then you've got the opportunity to recourse. Then you would look at the borrower and see what their strengths might be. And if you need to enhance the borrower, use guarantees. Find someone else who's good for the money and have them personally guarantee them. The next thing is it a legitimate asset valuation? Don't go for funny appraisals. Well, why do it? Let's get a fire sale appraisal. I mean, we accuse the banks of doing that now, which they do, because appraisal rules now have also fallen under the CFPB, and they've told them that austerity is better. Remember, for an appraiser today, it's better to wrongfully reject the loan by saying that it's worth less than it is to inflate the value so that they can get the loan. In other words, even if they don't qualify, it's better to put in a low appraisal so you don't have any liability in the future to the CFPB. So most of these appraisers are not seeing as much value as they once did as a prophylactic measure to protect themselves. But get a legitimate appraisal. BPOs, sure, I think that's viable as long as it was somebody that knows what they're doing. You get a legitimate borrower valuation. Don't go for funny money. Actually do verifications of such things as balances and values that they show. so that you know that your borrower is not pulling your chain. You get FICO reports, tri-merges, but verifying that they've had a reasonable past and that they've got assets out there, that has some value to it. Paperwork well vetted through an educated attorney, mortgage broker, or licensed mortgage originator. You've got to have paperwork that's right, and it's not just something right off the stack at the escrow company. Trust deeds can be changed radically in value, and so can notes, by being written well and giving certain rights that you wouldn't otherwise have. Let me give you one really good example. An instrument that doesn't have a perpetual ability to check the borrower's credit means that the only time the borrower can be lawfully checked is at the time of origination. But if you're going to sell this note a couple of years down the road, or you're going to sell it to somebody that wants to periodically check and see how secure they are by assuring that the borrower has maintained their creditworthiness, then they don't have the ability under the federal law. That's over, unless you've written into the instrument that they can. There is no instruments out there that I've ever seen coming from an escrow company like that. How do you write a variable rate note? You may want a variable or a floating rate. Do you know how to write one? I'll tell you right now, if you have some 21-year-old young lady down at the escrow company write one, what you've really got is a ticket to the courthouse, probably not a note, because that's where it's going to end up going. Those are very complex. Use the right kind of instruments and use ones that are heavily vetted in order to maximize their value. And those are not forms. Those don't come from the bookstore. Also, make sure that the instrument is capable of being properly transferred. Let's say you're going to buy one of those. It's already been originated and it's ready to go. Every escrow I've seen out there, except the educated ones, and wow, there's not very many of them. I'm sorry to say this because I do work with a lot of escrow companies. Every one of them thinks that you're going to sign a note. You cannot assign a note. You cannot be a holder in due course, in other words, the buyer, with all the rights that a holder in due course gets, which is free of defenses and other claims that might go along with that note, unless you're a holder in due course under Uniform Article 3. The only way you can do it is negotiate the note with an allonge, where it is endorsed over to the new holder. I can't tell you how many notes and trust deed assignments of beneficial interest we get to that are maybe third and fourth generation through sellers and buyers, and it turns out that way back at the beginning, the instrument was transferred by an assignment. The title to that instrument is questionable, and the defenses are manifold, and they run all the way down to the present. I would discount that instrument seriously, or I would go back and find every single one of those transferors and transferees and redo it as a negotiation. Remember, notes are very much like a check. What do you do when you go down and cash a check? You endorse it on the back. You actually physically endorse it on the back. Craziest thing. But that all comes out of Article 3, which also governs checks. And it says notes have to be the same. They have to be endorsed. Now, if you can't do it on the instrument, then you do it on an allonge that is attached to the instrument. So get the right paperwork even for transfer. And if you buy it, make sure the right paperwork is done before you got there so that you are truly a holder in due course, the highest status that a buyer can have. Title insurance. Realize that every time that instrument is sold, the old title insurance is gone. So you've sold the instrument, you originated the instrument, and now you sell it to somebody. If you're a buyer, do remember the title insurance on that instrument is gone. And even if it was still there by terms of the policy, in which very few policies say that it's not gone, you're not even a co-endorser, an assignee, for a payoff in the event that there is a loss under the title insurance. So you're virtually out. And some guy 4 generations back in that transaction is still the one that is the endorser that's being paid over in the event that there was a title claim. But the reality is, in most cases, you have no more title insurance. You need to get a bring down. You need to go to the title insurer that originated it, because they're usually willing to do these cheaper than a brand new title company. Take a look at it and get a bring down. You need a collection escrow. Why? Because it stays the same forever. And that means that the new guy just inherits it, and it also keeps track of the beans. It counts the beans right. So there's no argument at the end where the borrower says, well, I only owe you $216,000 for payoff. And you say, oh, hell no. You owe me $310 when they were doing direct interaction with payments. Because, of course, that week in the mail over a period of 7 years, and sometimes it was 10 days late, sometimes it was 5 days late, that actually added accumulated interest, and now everybody's arguing over what the payoff is or how much interest to declare on their taxes. The only way to do it is allow collection to do that, and they'll send out K-1s at the end of the year with allocated taxes, and that solves that problem. So everybody puts the same amount of taxes on their tax return, and you know what the payoff is. And then the last one that I put in there is a yield that fits the market and the portfolio. That has to be built into it to begin with. I typically like notes that have a variable rate feature. Sometimes I can qualify people a little bit easier with a lower feature. The new CFPB says you have to qualify them at the highest rate your note can go over the first 5 years. That's not difficult to work with, but it gives you a little bit better note, a little bit better security that if the market starts changing, the feds do change their policy on interest and it does go up, you can go up a little bit and try to stay at market level. And then I probably have one last thing that would be worthwhile talking about, and that is the insurance. You know, the casualty insurance on the property typically has the payee of the last holder of the mortgage. Now you're the new one that bought it. Are you the loss payee in the event of a loss on that home? Probably not. Not unless you go down to the insurance company, the casualty insurer, on the underlying collateral and make sure it gets changed. I can't tell you how many times people don't do that. Now when an instrument like that comes to us, and we're counseling a buyer, everything's wrong. The title insurance is lost. It's been lost maybe 2 or 3 clicks back. The insurance, casualty insurance, who knows where that's at? Half the time you find out you didn't even get notice and they haven't been paying it for the last 2 years because you're not on that list. And the last guy who was, he long since sold it, so he didn't care when the notice came in the mail that it was no longer insured. And you got assignments up and down that every single one of those has contaminated the title, so now you have less and less of a sound title. Won't go into what constitutes sound, that's a lawyer issue, but you have less and less of a sound title that a good buyer that knows how to look at paper is going to discount for. So those issues are the kind of things that you lose value. And so if you do it right from the get-go, and you transfer it right from the get-go, or you buy it by doing the due diligence when it's been originated by somebody else, to verify under due diligence that it's been transferred properly and all those things are intact, now you've got an instrument that's going to have a high ability for not only reliable yield, but for a very good sale because it's got every bell and whistle in place.
So Terry, experience clearly shows and has shown that on the transactions that we've worked with Jim where we have been able to handle a client's origination of a note or the brokering and sale of a note, experience has demonstrated that we've been able to generate tip-top dollar for these transactions on behalf of clients, have we not?
Absolutely. And I believe that it's going to be more and more important as time, like Jim says, there's a legacy that goes with these. And it's not what you're doing today, it's what you're going to end up with 5 years from now when there's an issue. So.
And just to shed a little more light on what this, because this is a good question, I think. How steep, Terry, how steep could we absorb a discount on the sale of a note if it's not done in compliance and upon these issues that, just to throw out some numbers, and if we're going to play with some numbers to throw out there to put it in perspective in terms of this particular individual's question, how bad could a discount be? I mean, I guess it could be 0, right? It could be 100.
Theoretically, it can get pretty bad. For one thing, I probably should say something that I'll probably regret later, but I will mention it. I did have a client that is a fellow that has an awful lot of guts, and he has been buying non-complying instruments and essentially just taking his chances because I think there's things in these instruments that if it ever got to push or shove could cause him an awful lot of liability. But the way he did it is he's been getting guarantees from the seller that they will indemnify and defend him. So he's not necessarily discounting them so much, but if his seller of that paper is really solvent, and he relies on them that they would be good for the check if it came up, he'll take it off their hands, but they've got to indemnify him. Now, they may get their dollar figure that they were looking for, or he may get the discount that everybody could find merit to, but in reality, for that seller, it's a terrible deal because they're on the hook. Should any one of those things explode, they're out there facing suits that are, at this point in time, completely unlimited in price, and they would certainly be exposed to having to buy that whole note package back if it was contaminated. So are people selling these things like that? And that's worse than junk. That's felonies, I'd call it. Let's see,
sure.
Selling causes of actions on felonies. Does that have any discount value? Well, if somebody wants to take the risks and wants to negotiate a deal between each other that shifts the risk, then they may still get a value out of it, and they may even ultimately end up collecting. But at a terrible cost, potentially, it's a huge risk that I wouldn't advise anybody to take.
Sure. So next question.
Well,
If
we're 15 minutes past, so let's not overuse Jim's time here. Let's
these are a couple of yes and no questions.
okay.
If you want to originate seller carryback notes, does a partner need to have an MLO license, standing for Mortgage Loan Originator License, or can one bring in a MLO to work with you and be covered to meet Dodd-Frank if you're doing more than 3 transactions as an investor?
I can do this a little more shorthand, and that's a really good question because those are the things that come up almost all the time, especially if you're a real estate licensee. So you're at the place where things are being originated, or you hold a lot of properties, small properties, and you're selling them and carrying back. It comes up, and more than what you would normally think. So as to the question, when do I need to have a licensed mortgage originator involved in my transaction on a seller carry? First of all, it has to be, as I said before, consumer paper. It has to be something where the person is going to occupy it, or a member of his immediate family is going to occupy it for more than 15 days in any given year, and it has to be for personal, family, or household use. If it is, then there are cases where you don't need an MLO, such as it's a single sale by one person who has not sold any other property. They're looking at the seller now. 12 months prior to that transaction or 12 months after. That's the mom and pop. They have the one family home and they sell it. You don't necessarily need a licensed mortgage originator, and you can almost take any kind of borrower with any kind of creditworthiness you want, and you can make almost any kind of a deal with them as long as it doesn't violate HOPA and ALTA and a couple other things which are on my website, so you can look there for them. If, however, you have sold more than 3, let's just go to that stage, 2 or 3 kicks in an MLO, or more than that, obviously you're going to have a licensed mortgage originator. Now, you don't have to be one yourself. You can hire one. But here's what my suggestion would be. To make this a little easier about where's that break, where do I really need one? Again, I have that on my website. It's at www.eckleylaw.com, and go through there and type in MLO and the subject box, and it'll search through those articles and it'll find it. And it will tell you the difference between the 1 property exclusion, the 2 to 3 property exclusion, and the over 3 exclusion. Most of the time, if you're a dealer and you've done a lot of deals, you've sold a lot of properties back and forth from your own portfolio as a seller, the likelihood is you're going to need an LMO, and the likelihood is if you're doing a consumer transaction, you will have to comply with truth in lending and HUD-1s and GFEs and things like that. Now, if you don't have those things, that's why you use an LMO, because they've got them, and they generate them off of disks or an attorney to help you out that has the appropriate paperwork, so that your consumer gets all the appropriate disclosures that they need to make this an enforceable loan.
You know of any good MLOs that you recommend, Jim?
Yeah. There's 2 guys I know about over in the San Diego area, and they finished their parole, so I think Terry, Mark, you guys are the best I know. So I'd like to see you flourish out there by giving you a good recommendation, and that is your work's always clean and you're always right on the beam.
Nice, nice.
Thank you. Appreciate that.
Well, yeah, let's move towards wrapping this up. Any thoughts, Terry? I know that we could talk about this forever because it's a topic we're all passionate about equally, and certainly the space changes each and every day, and as it continues to shift and evolve, you got to stay on top of it and read.
I just would like to thank Jim for his time, and we'll be at the Noteworthy Convention. I don't think it's sold out. There's over 700 attendees there. We're not part of it as far as we're promoting it, but who's who of the whole industry of the country is going to be there. So, and there's a lot of people that have a lot of knowledge, and I would like to thank you, Jim, for participating tonight, and we'll see you in a week. And thanks for the attendees as well.
Yeah, thanks for sharing your time with us, and we know you got some value out of it. You know where to find Jim. He's at www.eckleylaw.com. That's ECKLEY law.com. You can see his phone number listed there at 800-999, the number 4, LAW. That stands for law. And if I had to tell you that, maybe he would rather that you didn't know that. Anyways, you can find us at www.sellerfinanceconsultants.com. And on our website, it has all of our information, how to get in touch with us. We'll look forward to hopefully seeing you at the Noteworthy Convention. And if we don't see you there, we'll certainly see you in the future. We're going to be speaking at quite a few events throughout Southern California in the coming months as we close out this year and as we roll out the second half of the Noteworthy Convention. And that being said, we'll hopefully have Jim on, and hopefully we can convince him to share some more of his time and thoughts and experience with us in the near future, hopefully for the end of the year, and if not before the end of the year, hopefully early in the next part of next year. That being said, have a great night and great week.